The record date is October 10th, 2007. The CPI report, Child Protection in Iowa, brought to you by Vocal, Victims of Child Abuse Laws. You can watch our program on Mediacom Channel 15. It's aired on Sunday afternoon at 1 o'clock and again on Wednesday evening at 9:30. You can email us at vocaliowa@mchsi.com, or we're here to receive phone calls to try to give you our thoughts from our personal experience. My number is 515-276-3956, and John's number is 515-282-2672, and this is in the Des Moines area. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. CPI, that's Child Protection in Iowa, or sometimes they'll call it Child Protection Issues. And there are a number of child protection issues. There's a whole organization that's built around protecting children and gathering all kinds of federal funds and state funds to make sure that families are safe. And by the way, that's one of the watchwords that they're using now. And they can put almost anything under the terminology of safe home, safe this, safe that. So if the child is not safe by their definitions, and by the way, you don't find those kind of definitions in the statutes. So these are just dreamed up definitions that they've used themselves. They're attempting to get their definitions straight so that people who are providing the services for DHS and the people who are paying for those services within DHS, that is the ones who are handing out the money, are speaking the same language. And so I must applaud them for doing that, doing something like that. They're also looking at such things as best practices. Well, they're making some attempts, but if you look at the record, if you look at what's happening with respect to the Supreme Court and the Court of Appeals, seems as though there's family after family after family that is being seriously disrupted as a result of the work of the Department of Human Services. So they must be cranked up to do a very efficient job confidentially in tearing families apart. We're going to look at one particular case that came from the recently came from the Iowa Court of Appeals, and it was recently also appealed to the Iowa Supreme Court, and the Supreme Court declined to look at it again. Before we do that, I want to make one mention of a situation that's called extended media coverage. Whenever I go out with my camera, I do such things as record events in courtrooms, not so much anymore in the Polk County courtrooms, but I go out and do some recording from time to time in courtrooms and Department of Human Services and other places where there is newsworthy events happening, so that the people in this that's watching this program have an opportunity to see things that they wouldn't otherwise have time to take in, and things that are important enough because they have to do with the way the government spends money, the way the government attempts to wield its influence, and the way that the government deals with families. And I think that's something that every citizen should have some interest and probably should have some say about. It doesn't seem as though that's happening. Well, the whole thing is called extended media coverage. That permits people to be in the courthouse doing videotaping. However, the chief judge of the 5th District has decided to put some restrictions on that freedom of the press. It's strange that our founding fathers did not find it necessary to restrict freedom of the press. So, the fellow could go down the lane on his horse and ringing a bell and say 1 if by land and 2 if by sea, and nobody would say that that's not a media person. Now they want to impose all kinds of restrictions. Well, one of the restrictions in the Polk County Courthouse is that you can't have a camera in the courthouse. In fact, you'd better not be shooting any pictures even with your cell phone. You better not have a tape recorder in the courthouse, because some judge may say something he wishes that he didn't say, and you would have him on tape. Wouldn't that be a terrible thing? Well, for some reason or another, I was called into a hearing, and the only part I had in the hearing was the fact that I had made a request for extended media coverage. And the judge called me forward and swore me in and asked me question after question after question regarding my extended media coverage request. Asked me if I owned my equipment, who owned my equipment, where the equipment was, what kind of equipment I had, what was what camera did I use. I have a professional Canon GL2 that I use on my field events.
Well,
And
can you? I don't mean to interrupt you, but what
Okay.
was the purpose of all those questions? Are they just trying to thwart you from recording there? You think, or
The judge said he needed it on the record.
for what purpose?
that's I think that's
Are they going to list your equipment on eBay, or what? I don't understand.
I thought it was strange enough to make mention of it here on cable. They asked
Yeah.
if I was an employee of MediaCom. They asked me all kinds of questions.
And they made you testify to all this?
Yeah, right. I testified under oath, and I said, for greater than 25 years, the Iowa Supreme Court has sanctioned the use of cameras in the courthouse. Not only that, but they have dictated that the watchword is openness. And I said it would behoove this court to obey the dictates of the Iowa Supreme Court. And so the
So
judge says, well, you get your EMC. But
What judge- what
I thought
judge
that was
was this?
ridiculous. What
Judge Moore, Richard D. Moore.
Richard Moore,
I guess he wants less cameras in his courthouse, huh? More wants less.
less is more, or more is
Oh
less.
my gosh!
More is less,
Wouldn't
more or
that be a
less.
chilling effect on First Amendment rights?
It would be indeed a chilling effect on.
If he
Well,
was to do that to everybody?
I haven't gone back very often to the
Wow.
Polk County Courthouse simply because of the kinds of attitudes that they have toward so-called openness. They discuss all these things in an ad hoc committee. Because it's an ad hoc committee, the committee is not open under Chapter 21 of the Iowa Code. And because of
that means they're stealing something. They're hocking it. They're hocking your rights.
That's correct. Don?
Keep in mind, Richard Moore, the judge you're talking about, in the 1990s, was chief judge of the Polk County District Court and the surrounding area, going down all southwest, almost all of southwest Iowa, southern Iowa, east toward the east. He had quite a coverage, so his attitude affected a lot of people back then. He is now senior judge, and even though he had to step down for under questionable circumstances from his post as in the 1990s there in Polk County as chief judge, he still can work as senior judge, and he travels from to different courthouses. But I'm not sure if he's 80 years old. He's getting pretty old, and but I'm sure he gets to pick and choose where he goes and takes on cases of interest because he's been around. He can, and some of the secretaries are actually afraid of him and just do what he tells them to do. That's quite an intimidation he has on people.
The main point I was after here, though, was to simply disclose that it appears as though this is part of a whole plan, of simply discouraging EMC coverage, when the Iowa Supreme Court makes it extremely clear that openness is the key word to these sessions. And to have a media person, well, in fact, they're not really sure they want to classify me as a media person. I've only been on television here for about a decade. And one program I've run is 11 years. This particular one is 10 years, and another one is in its 9th year.
Did you tell them all that?
No.
Yeah,
I should have. They wondered if I worked for Mediacom. They wondered who paid for the equipment and who pays for putting it on television. All kinds of silly things like that. Oh, and are your programs news? Are they commentary? Are they this or that? Well, you see, if you're going to allow people to have extended media coverage, and then you're going to question them in court as to their content, then are you not wiping out or at least putting a chilling effect on what they can and cannot do with extended media coverage? You see, I think when you get to be a big shot, you don't want anybody going around with ideas that what you're doing is wrong. Well, I think, Judge Moore, that was wrong. To inquire as to who owns the equipment, where the equipment is placed. Of course, that helps a lot to know where the equipment is placed, because people that want to steal the equipment will know where it is. You see, and they want to know if I own the equipment, and if I was, well, a whole bunch of questions that, that attempted to show that I was not a media person. Isn't it a shame that the Founding Fathers didn't know that this dispute would arise? They simply said there shall be freedom of the press. It shall not be infringed upon. I think, Judge Moore, you infringed upon freedom of the press.
Isn't there a whole lot of journalists that own their own cameras and their own equipment?
Sure.
So what does this?
Where's,
I don't understand the relevance of his question. Did you ask him?
No.
You know. There's all kind of media people that have their own cameras.
Ask him. You've got a venue for asking him.
Yeah, well, I'd like to know.
Like Judge Moore.
We want Judge Moore to tell us.
Yeah.
What's the purpose in all these questions? A lot of media people own their own camera. So if he didn't own his camera, he's not a media person?
Yeah.
Maybe he's getting senile in his older age. I don't know what's going on.
That's the way it goes.
It doesn't make a lot of sense to me.
No. We have a person who is the judge of the judges sitting right here in our studio. It's had some commentary even on this first judge type of conversation. Here now. Oh, did you want to talk?
Yeah, I got one more comment I'd like to insert in on this. The Iowa Code says that the judges and other state employees have to take not all state employees, but judges have to take an oath of office. Oath of office. And it goes on to say, if they do not, the office is vacant. It means it's as though there is nobody there. I did extensive research and requests for that oath of office, and I did find one back in 1980 under his name when he first became an attorney. But he then came in power into the district court over all of southwest Iowa, as I told you, in 1990s, until he got removed for questionable circumstances. But back to the oath of office, the courthouse could not furnish me with an oath of office for that period of time, and today there is no updated oath of office. I went to the Secretary of State, who keeps records. They have nothing on him.
Is it supposed to be a document?
Yes. First he makes a verbal statement. He raises his right hand and swears to uphold the Constitution of the United States and a few other words.
And the
like
state
that.
of the state of Iowa.
And I also went to three offices, I believe it was, where the Supreme Court judges are south of the Capitol. And I made requests in those offices. And they could not furnish me an updated oath of office. To me, I question that, and I've received emails and read articles where other judges get removed from the bench because the law says, even our Iowa Code says, the office is vacant if there is no oath of office, and they've never presented one during these years and up to today. There is no oath of office that I have found. That's strange that they can't produce an oath of office to cover when he was, what did I call the title when he was in the district court, Polk County in the 1990s?
He's chief
judge. Yes, chief judge of all of southwest Iowa, and had his office here in Polk County at the courthouse. John?
Okay. Back to our original introduction here, the judge of the judges, someone who is rather excited about seeing court reform. Terrance Walker.
Well, thanks a lot for having that great presentation of me once again. And yes, I am the judge of the judges here in Iowa, and through a small section of Omaha as well, or Nebraska, I should say. What is it that I think is essential when we discuss victims of child abuse and judges? I mean, we're basically trying to address problems, malfeasance that affect families and individuals. I think that's what we have in common. And it seems like here in Des Moines and Iowa in general, it seems like whenever we seem like we're making one step forward, we take two steps back. You know, when it comes to the judges and all this. And they've implemented this openness, and they keep talking about openness in government, the Sunshine Law, and all these great things. We're supposed to have a great free government.
Sunshine Law with 54 exceptions.
Yeah, so, you know, there you go. You can't have, exactly, goes back to my point. One step forward, 2 steps back. But in that case, 1 step forward,
54.
54 steps back. So that's exactly how Iowa seems to operate. Now, we've been discussing, like last time I was on the show, we discussed how, the justice system can sometimes, because of the people that are bringing people into the justice system and their prejudicial nature, can have an effect on how unevenly weighted the justice system can act. Now, we know that the justice system has been statistically proven over the past decade, actually 14, 15 years, uh, it goes back, that Iowa has had the poorest record on as far as disparate sentencing as far as black males especially. But not only that, um, it has also more recently been put into light as the number one state where blacks are disproportionately sanctioned in schools as far as being suspended. So, when we talk about the justice system, we've got to talk about the people that are out there, the pawns in the game, the ones that are bringing people into the system. So when we have a system that's set up with police and prosecutors, and in the instance where I'm talking about school officials, um, when talking about suspensions, we got those pawns in the game that they're not fair, then the system's not going to be fair either. So we've got this new cop, Judy Bradshaw, who's just recently been appointed as the chief of police here in Des Moines, who recently, this past summer, instituted a wave of, I would call, terroristic type tactics within the black community upon uh, unsuspecting black males and I would say underprivileged white people as well in the community, who and Mexicans, because I do have a guy that works for me that's Mexican that has been harassed by the police for having a license plate on his bumper, or not on his bumper, but on his dash, and the police just basically impounded his vehicle for that unbeknownst reason. I mean, I've never even heard of that. But with the wave of these terroristic type of activities in the guise of getting tough on crime, when you have these sort of tactics, it's no wonder that Iowa takes 2 steps forward, 1 step forward, and 2 steps back. In this case, they've taken many steps back, because I can't even recall back a dozen or so years ago when I have never seen these sort of tactics that have been taking place in the community. But and it just occurred to me yesterday that another one of my friends, a business associate, a fellow businessman, a black businessman in the community, he said he had got stopped by one of Des Moines' finest, and the officer who stopped him told him that he didn't quite make a full stop, which is why he stopped him. Now, I think, if we're going to enforce the law, I think we should enforce the law to everybody equally, but, it just seems to be more recently than not, they're coming up with all kind of excuses to stop people, to harass people, to go through their things, to impound their vehicles, and just to make a whole mockery of this thing that we call justice. Now, we've got, granted, there was I guess what they would call an increase in crime, this summer. A couple people got killed in the neighborhood, north side, that is. However, there's been a couple people that got shot and killed on the east side. There's been a rash of burglaries in Windsor Heights and Urbandale. A friend of mine that works for ADT has made light of that some new statistics along those lights. But when you have the pawns in the game, and those pawns are only focused with their efforts as harassing and terrorizing the black community, then it's no wonder that we're going to have inflated numbers of blacks in prison, because you don't see the police going out to Windsor Heights, pulling everybody over, harassing everybody for not fully stopping at the stoplight, for having the seatbelt under the arm instead of over the arm, as which my friend supposedly got told by the police yesterday. Um, you might know him. His name is Lou Parks, owner of Lucille's Clothing over on 25th and University. Uh, believe it or not, the officer told him, well, your seatbelt wasn't quite over your arm, it was under your arm, so therefore it's a seatbelt violation. So when you have the pawns in the game that grasp at straws to find anything wrong with you, it's no wonder that there's imbalance in this society, and and especially in Iowa, where we have the highest percentage per capita of imprisonment of black males. It's about 2% black in the whole state, 23% black in prison. That's a shame, and that's a mockery. And I think that it's high time that instead of just putting this information out there, letting people know about it, it's time that people act. So I will be letting you know my plan of action
Okay.
and in the coming weeks, and I will definitely be instituting some things in the community myself. Myself and Lou Parks have recently this summer instituted Family Fun Day, where we actually have had, basically activities for the youth in the park and a basketball tournament. Uh, Des Moines' Finest wanted to charge us money to have the black or some officers present, and this is a community event. Now, if we've got cops that are supposed to be so focused on stopping crime in the community, where were they at? They want to make us pay for having a positive activity in the park, but yet and still they'll put a armada of police officers on the street to throw black people in jail. But yet at the same time, when it comes to having a positive event where we can foster a positive communication and positive relationship with the community and with the police force, they're absent. They're gone. They want to make us pay for that. But we're taxpaying citizens. Why should we have to pay for that? Because I tell you why. I tell you the reason why. Because instead of reaching a handout, they rather put a boot on our neck. And that's a shame, and that's exactly why I think that we're taking one step forward with the election or appointment of a woman police chief, but who's also taken 2 steps back in the relationship with the black people and the black leaders within the community. But that's my 2 cents on that.
Okay.
And I just thought I'd put that out there because that's something that's been on my mind the past couple of weeks. And we're going to keep on that until the situation gets better and it gets addressed.
You bet. Well, thank you for that commentary of something that's happening in our community. If law enforcement is so busy worrying about whether you have your seatbelt strap under your arm or over your arm, then they're not prepared to handle the weightier things, such as the bank robberies and the break-ins and nighttime burglaries and so forth. It seems as though we want to have a huge force, and then they try to find ways of keeping that force busy.
And justify the force, and then
right.
justify, and then to make further money off of disadvantaged people in the neighborhood.
Correct.
Be it they black, be it they white, or whatever. This is not a upwardly mobile, high income community, but yet they want to charge you $80 to get your car out of the impound, $20 to get your car out of impound, and another $60 to I don't know, $20 administrative fee, and then $80 to get your car out of the impound.
Overnight storage.
Oh, overnight storage fees. You got all kind of stuff, and then A lot of times they'll stop people, like my installer. He had the tag on the bumper or in the dash instead of the bumper because he had a problem with it. Totally legitimate, but yet and still they want to tax him all that money for doing that for the ticket and pay upwards of $200 when you're talking about the ticket and the impound and the towing fees.
How about the insurance that goes up sky high
Yeah,
as a result of all this?
exactly.
for everybody.
And so they're using all these things to justify their activities. And I seen in the article that I showed on the air last time how, oh, we're having all these new stops and arrests and all this. A lot of these things are fabricated.
Bogus, yeah.
And
You
and the numbers don't necessarily mean that they're doing an adequate job. Numbers don't tell you the whole story.
That's right.
And when you still have people that are getting burglarized left and right in Windsor Heights and Urbandale and the West Side and stuff like that, then what are you doing? You're not doing nothing but making crime go from one place to the next. So you're not solving the overall situation of crime. You just spreading it around and
bet.
you're creating a false perception that you're doing a good job when actually you're not doing nothing but harassing the citizens in this particular neighborhood.
Yeah, and making an unfriendly, hostile environment when they should be serving the people. I think they forgot that word service. They're supposed to be to serve. I think some of the cars in other cities say to serve and protect.
Protect and to serve.
Protect and to serve. Well, in any case, it means the same thing no matter which way it is. But
Not to them, though.
It seems as though they have other agendas.
See, they're inside the car, and
Okay.
it's read backwards,
Now,
I guess.
It's bad enough if the police come up with bogus notions for stopping you. It's really sad when DHS comes up with bogus cases. To terminate a child, there are 3 pages in Iowa code that permits the Department of Human Services to initiate action which will wind up in juvenile court for the termination of parental rights. That is a very, very disturbing situation. When you look at the grounds, when you look at the reports that come through of the terminations each month through the Court of Appeals, it is amazing. And those reports are one after another and another and another, where they affirm the lower court decision to terminate the rights of a child. So we hardly need an appeal process. If the appeal process is nearly 100% to affirm the lower court decision, who needs the appeal process? Because it's almost impossible. But yet, like you say, Terrance, parents will dig down into their pockets with the $5,000 or $10,000 or $15,000 to take their case to the Supreme Court for nothing. And poor people don't have enough relatives to scrape up the money for cases. Let's look at one particular case. Can you put it up on the screen, Don? We're going to look at one case, and we won't spend a whole lot of time here. But what I wanted to do is go down real quickly through this case. This is a case that I have some familiarity with, not a whole lot, but I've talked to the father. I've never seen the 4-year-old son that was terminated from this father, but it's a sad situation. I did get to see the terrific judge, Louise Jacobs, who handled this matter. And what I did in this situation, and I think it's good, and you'll see the reason why as we go through the case, suggest to the father that if they're saying things about you and about your child which are not true, then you should consider writing a report to the court. And so this father wrote a report to the court. I thought that was a good idea. What's wrong with telling the court the truth of the matter as seen by the father? Well, Louise Jacobs decided that that was practicing law without a license, and asked this father who encouraged him to do this, who helped him to do this. He said, well, his mother helped him. And then in the courtroom, she also said, well, who instigated this? How does it, uh, how did it come about that you decided to do this? Well, John Harvey suggested it. Which is the wrong thing to say, I suppose, but then she took after John Harvey and said this was a violation of this was practicing law without a license, because I wanted a father to have a halfway chance with the district court. Forget halfway chances, especially when you have people like Louise Jacobs that wants to prosecute people. She said this ought to be taken to the Supreme Court. I said, bring it on. I think it would be wise.
I don't think they have a bad chance in hell anyway, because I mean, you could tell somebody, you can go tell somebody that maybe they should jump off a bridge if they're
Yeah.
not happy with their life. If you don't push them,
Yeah.
then the mere suggestion does not make you a culprit.
That's right. Well, I don't think they want
ridiculous.
anybody with any discernment to be talking to people whom they've already decided are poor candidates for parents. Not every parent is a good parent. Not every parent has all the attributes that the courts would like to see in a good parent. I don't suppose that there are many people on the Supreme Court that are actually good parents if you looked at everything they did. Let's take a quick look at what happens in this particular case. And the reason I can give this to you as a public document is because it did go through the Court of Appeals, and it is on the public record. The father in this appeal, Anthony, they're not going to cover up his name, has a mild form of mental retardation. Now, is that a real good reason? Is that an excellent reason for? Is that an excellent reason for removing a child from the father that loves him? Well, that's what they did here. His former wife also has various mental health issues. Their 5-year-old son, Zachary, of course we're not going to cover up his name, has been identified as a child with special needs. Is that a real good reason to remove the child from the parents? The Iowa Department of Human Services became involved in this case in 2004 when Zachary was 2 years old. And at that time, Anthony and his wife were in the midst of divorce proceedings. Zachary was living with his father and maternal grandmother. The state filed a child in need of assistance, claiming Zachary was not receiving critical care. I don't know what the critical care was supposed to be, but because obviously I don't know all the details in these stories just because I talked to the parents once or twice on the phone. At the pre-conference hearing, the court inquired as to whether either parent was Native heritage. Neither parent claimed that they had any Native American ancestry. Zachary was adjudicated a China on that's child in need of assistance on September 27, 2004, and was allowed to stay with his father, but DHS eventually began removal proceedings when it received numerous reports of neglect. And it's about that time that I indicated that he should be talking to, he should be writing to the court, because if there's numerous reports, when the DHS says it and you don't resist it, it is taken as though it is gospel truth. For an example, Zachary's school reported that he often came to school with soiled diapers and with a ravenous hunger. A 4-year-old comes to school with ravenous hunger? Now that would seem rather strange. Anthony told one service provider that he sometimes allowed Zachary to bathe himself so Zachary could have some privacy. That seems a little strange. During one in-home visit,
A counselor probably put that thought in his mind too.
Zachary began to play with an electrical socket. Quite often, kids will play with electrical sockets. Anthony did nothing to stop Zachary, so the service provider had to intervene. Is that a real good reason to terminate, to separate a father from his son? The guardian ad litem who visited Zachary also found a cigarette lighter amongst his toys. Is that a good reason to remove a son from his father? I don't think it is. Well, let's see here if we can dial that up. Anthony made limited progress toward unification during the next 12 months. He received numerous services, but providers reported concerns over his ability to learn, to practice, and to retain essential parenting skills. Is that a good reason to terminate the rights of a son to his father and a father to his son? He required regular reminders to perform basic parental functions, such as when to give Zachary his required medication. Zachary did not respond well to the provider's suggestion and was very defensive. Is that a real good reason to remove a father from the son?
Sure, the social worker knows all the truth, knows how to handle a situation like that, whether they've had children or not. They know it all.
That's right. Now, of course, it behooves everyone who's under the authority of the DHS to bow down and to say yes sir, yes sir, yes sir, yes sir, master, I think it's supposed to be. And not doing that could wind you up, that remark could wind you up in the Supreme Court like this one is, and says that you were very defensive because you didn't say yes sir, massa. Anthony was also very uncooperative with the DHS caseworker and avoided communicating with him directly. While he was uncooperative with services, Anthony did make significant strides in all other areas of his life. He got a job at a local retail store and he was promoted to stock supervisor. He also rented his own apartment and took steps to childproof the home. And Anthony eventually progressed to 90-minute unsupervised visitations. However, he never progressed to the point where overnight visitations were appropriate. I wonder why he was never able to get I wonder who made that decision.
Well, they don't.
Well, the same people who wanted to part father from son made the decision that he never progressed. How could he progress unless he was given permission to have that child overnight?
That's what you call
a chicken and egg argument,
it doesn't have any logical flow to their reasoning on this opinion, because for one, if you can't progress unless it's something that, I mean, when you talk about progression, you're talking about somebody that is doing something on their own volition.
That's correct.
Now, if somebody's holding you back from progression, then that doesn't have anything to do with the progression that they're sounding like they're meaning in that sentence. But
right.
They should have put a more accurate term, which was DHS didn't let him
correct
visit his son overnight.
Right.
That would have been a more accurate assessment, but they're making it look like it was all on him, but they didn't put forth any facts.
And what was it he was to perform to indicate why was he placed in a position where he couldn't demonstrate this whole idea of whatever it took to get the overnight visits? I think they want to do the pigeon and corn type of thing, where they can train pigeons to do all kinds of stunts and tricks and so forth if you give him a kernel of corn. Apparently, they didn't give him the right kernels, or his training was inappropriate or something, so he couldn't have overnight visitation.
That opinion leaves much out. It leaves much to the imagination and much to be desired, and I would say that's a horrible opinion if that's all that's left of it.
I've
That's
been
right.
watching this pattern since 1985. DHS continues to do the same thing. They put you in a trap you can't get out of. There's no way you can prove your parental ability based on what they force you to do. The end result is you'll lose. They've got this all planned. Let's see, what is Santosky? The DHS has, Santosky is the United States Supreme Court ruling on a family situation. And the quote was, the DHS, everybody knows who that is around here, the DHS has the power to create history. And as soon as they grab the child and start controlling the parent and get that carrot out in front of the parents, they're hoping that they'll get their children back, then they're creating history. And they cause the parent and child to do things that make it impossible for family reunification. John?
That's right. I won't go through the whole story here, but it's kind of sad as I look through. I can't find anything that is substantial that would merit tearing a 4-year-old boy, he's 5 now, I guess, a 5-year-old boy away from the father who loved him. Of course, now they say love is not a real attribute of keeping the child safe. Love is something different.
Well, the keeping the child safe is just is another way for them to say, or it's a disguise for the true meaning of their intentions or their actions, which is he's not living up to our standards. He's not being in the home of our standards. And a lot of times their standards may be something that's based upon their subjective feelings rather than an objective appreciation
Correct.
of the fact that there's a natural parent or a natural guardian or natural relative there that's able to raise that child sufficiently. It might not be up to their standards,
Right.
But it's sufficient
Right.
and it should be upheld.
Don, were reasonable efforts made in this case, or did that issue arise, Don?
Reasonable effort. That's a federal term, isn't it? That the DHS has to fulfill, before they can terminate parental rights. And the document here John was reading goes on to talk about the reasonable efforts in this situation that the father found himself in. And so the question is, did DHS provide reasonable efforts prior to termination of parental rights? The order says here, throughout these proceedings, Anthony has tried to have someone else available to help him care for Zachary. My guess is that that's DHS thoughts they put into his mind, saying, if you want your child back, you have to have somebody else provide this care for you. On appeal, Anthony claims he was successful in the past in raising his child with the assistance of a live-in, and contends the state did not make reasonable efforts to assist him in finding or improving an individual who could provide support and supervision, which could have aided in the reunification of the family. So DHS failed there, according to the father. The DHS has all knowledge. They have all talent. They have all ability to get things for their best interest, but they can't provide it to the parent to make a better family. So the ruling goes on where he is disagreeing with what DHS has done. The court is saying here, we disagree. For there is no evidence Anthony ever successfully raised his child with the assistance of a live-in. Zachary was adjudicated a child in need of assistance because Anthony could not provide for his care. The court allowed Zachary to remain with Anthony, and Anthony utilized both his mother and a nanny to help him care for Zachary. Even though he received his assistance, Zachary was removed from his care amid numerous reports of neglect. Second, we find that the state's efforts to assist Anthony were, under the circumstances, reasonable. As mentioned above, Anthony initially utilized a nanny to help him care for Zachary. When he inquired about hiring another nanny, DHS performed a background check and found this person acceptable. For unknown reasons, Anthony decided not to use this person. Anthony suggested another individual, but this person failed the DHS background check. Isn't that interesting? The only person that'll work is the one DHS picks.
That's right.
Doesn't make any difference whether it'll work in the family or not. It's whether DHS approves of it. Anthony suggested a third person, but DHS found this person unacceptable because she was not cooperative with the foster mother. We find no merit to Anthony's argument that the state efforts were not reasonable simply because DHS rejected two of the three people he suggested.
She was not cooperative with the foster. What does that have to do with anything?
Also, I say, did he have a...
But I'm saying if the child was going to live with them, the foster mother would have been out of the picture. So what does that have to do with anything?
Doesn't have to make sense if it's bureaucratic.
No, it's just a bunch of nonsense.
Let me make one guess. This father had a court-appointed attorney approved by the DHS to represent him in court.
Okay.
If I was a betting man, I'd win. I would guess 99% of the time, if not 100.
Well, I think it's a sad story, and that's the reason I wanted to bring it to your attention. It's we don't get to see the background of these things until it's way too late. We don't know what the department's doing in these cases, and it's difficult to review their performance in accordance with, to see if what they're doing is in accordance with the statutes that the General Assembly has mandated. So no one knows what goes on inside until after it's too late. And then once it's written like this and the Supreme Court refuses to review it, you're pretty much dead in the water. And son will never see father again until he's 18. Sad, sad story. Well, I want to give you just a brief introduction to some meetings that I did some videotaping for, and these have to do with explaining to the Department of Human Services Council the kinds of things that are happening in Polk County. In the Polk County area, there's 14 counties that are involved. And here's the story of the marvelous things that are happening in child protection in that Polk County area. Here now, the Department of Human Services.
All right, okay, that's all, great. I'm Beth Avery, and I am Child Protection Assessment Supervisor. I'm going to stand up because I have the right distance to my paperwork. I use my glasses. Like Wendy was saying with Life of the Case, it's what I'll be focusing on is the delivery of those child protective services that
This is
we try to deliver in
Beth
a way that allows for the
Avery.
continuity of transition between assessment services into our child protection ongoing services, while also integrating community services into helping that family in dealing with the problems that they were dealing with that brought them into our system. Trying to reduce any sort of redundancies in information gathering, while moving towards safe case closure. And of course, our goal is always to reduce reabuse of children. The first thing that happens, the first that we find out that we are needed to be involved with a family is through intake. Generally, we get, most of our intakes come through the phone. Occasionally we'll have walk-ins, but for the most part, we get calls in. We have a dedicated intake staff that just works doing intake. Last year, our intake unit took, I believe, 5,000 calls. It's a very busy unit, and it has its own supervisor. When the call comes into intake, that intake worker is responsible for gathering all the information with regard to what the family is, the name of the family, the address, their location, so that we can find them, what the allegation is, what the concern is. That worker will translate that information onto the form, but in a way so that it will meet whether or not we will be able to do an assessment in that case. Our workers are also responsible for doing what we call lookups, which means they look into the system to see if they look into the IABC system, which tells us whether or not there is public assistance involved with that family. That helps us because we can then find birth dates, social security numbers, citizenship, current addresses. They also look into the system to see if there's any ongoing services currently involved with that family. They also look to see if there is any history of child protection involved with that family or any current child protection assessments in process. They also, if appropriate, look into the driver's license if we're having trouble locating where the person is at, what their identity is, and also have the ability to look into criminal. Our informants are basically, we have mandated reporters and permissive reporters. Mandated reporters are people who, in the course of their employment, come in contact with children, and if they reasonably believe that a child is being abused, they are required to contact us. A permissive reporter is anybody else, neighbor or whomever in the community that has concerns. They can call us. We prefer that they give us their names, but if they don't, we also take anonymous calls and give them the same weight that we would give any other call that's coming in. We also have what we call mandated reporters reporting permissive. Now, mandated reporter is not mandated in every facet of their life. It is only when they're in the course of their employment that they are mandated to report. But at other times, if they come across a situation that they're concerned about, they certainly can call us with regard to that as well. When we have an intake that comes in, we are looking for the criteria in order for it to be able to meet the criteria in order to be accepted for assessment. There are 3 areas that we have to have in order for us to be allowed to take a look at that case. First of all, we need to be talking about child. Second of all, we have to have an allegation with regard to a caretaker, alleged perpetrator. It has to be a caretaker. The reason he kind of looks like that is because that is your, what comes to mind when you think about an alleged perpetrator, but really that's not such a good picture, because although historically people will say we need a baby, a brute, and a bruise, really what we're talking about are families that are having maybe going through a bad period of time where they need some assistance. But the last picture is of a bruise. We need an injury or an allegation that a child is not receiving adequate care. In Iowa, we have really nice definitions of neglect. Neglect, to me, when you think neglect, you think, anything could be neglectful. But if you take a look at how Iowa has defined it, they talk about denial of critical care, which is much clearer. So if you look at how is this child being denied critical care with regard to supervision or with regard to shelter, what is it about that causes us to believe that critical care is not being provided to that child?
Explanation of the child protection system as handled in Polk County, Iowa.
Physical abuse, we're requiring that it is some sort of an injury that requires a healing process. And usually the lowest form of an injury would be considered a red mark that would last longer than 24 hours.